The Honorable Supreme Court of the State of New Mexico.
Good morning. You may be seated. Thank you. Good morning. We're on the record of S1 SC 40487 interlocutory appeal, State versus Trevizo. We have on opening 20 minutes. You may enter your appearance and proceed.
Thank you, Your Honor. Michael Thomas, NMDOJ, Raul Torres, Attorney General for the state.
Morning. You may proceed.
Thank you. May it please the court, counsel, and attendees. This case, still at the pretrial stage, involves two narrow legal issues, specifically whether the district court's decision to suppress evidence was factually supported and legally sound. The district court erroneously concluded that there were violations of Miranda and of the physician-patient privilege. Many of the court's key findings are either not supported by substantial evidence, or even if they are, do not support any assertedly related legal conclusion, revealing that the district court was mistaken about the applicable law. The interaction of the doctor, other medical staff, and defendant, as well as the police, are captured on the lapel video in the record as Defense Exhibit H from the suppression hearing. A careful review of the video is critical to a proper understanding of the issues, as it undercuts a myriad of defense assertions and glaringly fails to support and outright contradicts the district court's findings, as well as various characterizations in the ruling.
Counsel, I'm going to interrupt you in two things. First, you need to slow way down. Second, I'd like you to address pretty much right out of the gate State versus Ibarra.
State versus
Ibarra. It seems to be a case that answers this question a little bit.
And I'm not immediately familiar with that case, Your Honor. I'm sorry. I'll try to do my best to answer your question.
Okay, so I'll try and tee it up a little bit for you because I don't want to completely catch you off guard. So this is a 1990 Supreme Court case. And in that case, it's discussing the term interrogation for purposes of Miranda, which seems to be an issue here. And it says that under Miranda refers not only to express questioning, but also to any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit incriminating response from the suspect. So that's that concept. Does that help?
Yes, and,
Okay,
Your Honor, and I do remember Ibarra. Sorry, I didn't understand, but then I recognized it was Ibarra, which is cited in the brief. So
Yes. Okay. No, that's okay. So I would like you to address that statement that comes from Rhode Island versus Innis, but was adopted by the New Mexico Supreme Court.
Yes, thank you. And I do recall Ibarra in the briefs. Your Honor is right that interrogation under Innis can be express questioning, or it can be, as Rhode Island Innis talks about, actions or statements by the police that are, as they say, that the police knew were reasonably likely to elicit an incriminating response. The reason why the state believes there's no interrogation here, Your Honor, is when you look at the video, just so we're all starting from a baseline, the police do not ask her any questions at all. The police do at one point ask the mother, does she have a driver's license? They hand that over. Of course, they're going to run everyone for warrants, like showing up at a car accident scene. But as I cited in the briefs, we all are familiar with cases that say they're asking for a driver's license name, that's procedural, that doesn't count as interrogation. So then the question would be, did the police say anything that would be, as Innis says, reasonably likely to elicit?
Well, it's not saying it can be actions as well. And that's what I want to focus on is actions, because I get that the police didn't say anything, they didn't ask questions. But here my concern is that if we only review the video, and that's out of context to what the police have been told prior to going into the room. There's been a report. They've heard from the nurse, probably things maybe the nurse shouldn't have told them. And then they're invited to go in. And so there's action as a result of that that's different than like they just pop their head in or if the report had just been made without healthcare folks tying the report to this young lady. That might be different if they were just going room to room saying, we'd like everybody's name and information. But here they had this body of knowledge before they walk in the room. And that's what troubles me in this case.
Yes, and I'll do my best to answer. And of course, I know we'll get to the agency issue later, that the other side is arguing that the doctor was an agent. But yes, just strictly actions of the police. And I do appreciate the court's questions in focusing this. We know that it's an objective test for custody, but now we're talking about actions that can be arguably that would have caused or been the equivalent of interrogation under INIS. The state doesn't believe the police did anything here. I'm glad that Justice Bacon brought up the question of, well, that the nurse went up and talked to the doctors. The charge nurse went up and talked to the police when they arrived at the hospital. I don't see a problem with that because, I mean, generally when the police arrive at a scene, they're going to want to talk to the reporting party. Now, granted, the doctor, whoever it was that called the police, the reporting party here is a little ambiguous. It's essentially the medical staff, the hospital. It's not like a neighbor calling the police on a loud party next door, but the police naturally are going to want to talk to the doctor, the nurse, get a little bit of information before they barge in there. I think the police acted very reasonably here. They talked to the doctor, they talked to the nurse. And I think the police are smart enough to realize that just because this charge nurse is telling them this, that, and the other, that's just for the police officer's information. The defendant didn't even know what was being told to the police. So my point being that nothing that was said to the police in the hallway would have even been known to the defendant. So going back to the justice.
But that's always the
Counsel, my concern here is, and I'm curious, why did the police feel like they needed to go in the room with the doctor while she's talked about the defendant's treatment? Because the doctor told the police before she went in the room, I need to go tell her about what her condition is and what we need to do next. And then she says, will you come with me? Which I find a little strange, but why did they feel like it was appropriate for them to go in the room with the doctor to discuss treatment?
Well, I would say that at that point, they clearly had reasonable suspicion, probably more than that, given that the medical staff was, and I'm doing my best to answer your question, the medical staff clearly knew that the only person that had been in the bathroom during that entire relevant time was the defendant. This was not going to be a whodunit. So you're right, the doctor does say to the police officers, look, I need to tell her what's going on. I got her accepted to Loveless and Roswell. I need to tell her what's going on. She's bleeding. I need to make sure she's stable. The doctor simply says, does one of you want to go in there with me?
No, that's not what he said. She says, I need to make sure the mother is stable. I don't know if she delivered a placenta. She's bleeding a lot. And she immediately asked the officer, quote, if one of them is willing to be part of the conversation, and invited the officers into the hospital room, and they both agreed. So that's, I want to be clear on what the facts are. And she says, I want you to be part of the conversation, and they both agreed. Secondly, and maybe this is another way of asking the question that Justice Vargas asked, is there any medical reason for the officers being in the room when she's confronted? Is there any medical reason for inviting the officers into the room?
I would say I don't know that there was a medical reason for them to be in the room, but
is there any legal, any police reason? Is she a threat? Is she getting up and running away? Is she doing any of those things? Is there a suspicion she has a weapon? Or is there any police reason for them being in the room?
And to try to answer your question, Justice Beal, I appreciate it. I've watched the video about 10 times. My memory of the video is I don't remember the doctor saying, do you want to be a part of the conversation? I remember her saying something like, does one of you want to go in there with me?
But assume for purposes of this, that that's what happened.
The answer, I do believe they had a legal reason to be in there. They were conducting an investigation.
Investigation of her medical condition?
Well, investigation of what led to the baby being put in the trash.
No, she says.
But if they're investigating.
She says.
We got Miranda.
Well, Miranda requires custody and interrogation, which I'll get to in a minute. But My point is that there's no legal bar to the police going in the emergency, in the exam room. Now, granted, I admit it. And the doctor said, look, I need to talk to her. I don't want you in there yet. Can you hold on while I talk to her? I think the police, you can tell from the video, they were very deferential to the doctor. One thing I wanted to point out, because I believe now is a really good time to say that, there's a lot in the answer brief that suggests that the police presence there caused a delay or hindered treatment of some kind, or even delayed possibly her being flown to Roswell. I want to be very clear. There is absolutely zero evidence in the record that would support any fact finder in finding that any medical procedure or care was hindered or delayed, or that they even had anything to do with the helicopter arriving. So what I would say is, the best answer I have is I don't believe there was a medical reason for the police to be in there, but clearly the doctor did not say, I want to talk to her in private. I don't want you in there yet. I know we called the police, we called you, but please don't go in there yet. I need to talk to her. Do they have a legal reason to be in there? Yes. Now, might it have been
What's the legal reason?
Well, they're investigating this, and they probably want to, at some point.
Watching her get a pelvic exam, is that investigation?
Well, later on in the video, when there is a point in the video when the nurse says, will you two please step out? And the police do. They step out of the hallway because there was probably some, medical.
Was that hindering their investigation? Asking them to leave?
No, it wasn't hindering at all. And the police were very polite. They went out in the hallway. Another thing I wanted to mention too, and again, I think some of this is more clear when you sort of watch the video from beginning to end. There's a point in the video, pretty much exactly at 3 o'clock, where you see the police are out in the hallway. And they say to the nurse, they say, well, we don't really want to go in there and cause her more stress. She's dealing with a lot. And at that point, at 3 o'clock, you see the sergeant and the other officer go back into the room when they've clearly been out in the hallway. And the sergeant says, look, we're going to continue waiting out in the hallway. We don't want to add to your stress. We know this is stressful. And the sergeant even explains, we can't have your mom in here right now. We're waiting for the detective. You are 19 years old, but we're going to keep waiting in the hallway. We don't want to add to your stress. I know at answer brief, page 9, it certainly seemed to be making the claim that the police were in their room the entire time for that 2 hours or 2.5 hours. And that's just not true. From 3 o'clock until she was taken away by the helicopter at 4:30, pretty much 99% of that time from 3 a.m. to 4:30, they were waiting out in the hallway. And I don't know if I answered your question, but
But that was after the incriminating statements were made that were suppressed.
well, yes, but the one thing I hadn't gotten a chance to get to yet was that it's 3 minutes. It's 3 minutes into the lapel video that they tell her, you're detained. You're not under arrest, but you are being detained. Put aside, of course, the cases that talk about being detained is different than being in custody for Miranda. Even if this court believed that she was in custody at that point, 3 minutes into the lapel video, and everything else was suppressed, she had already made the statements. And that's why I mentioned in the brief in chief that the motion was a little bit broad, and not the other side's motion was a little broad and not limiting the request to exclude statements to at least the point where she was told, you're not under arrest, but you are detained and you're not free to leave. But it was a little bit overbroad. And the case here, I'm trying to find the case really quick. Yes, State v. Philemon v. 2018 NMSC 11 talks about the difference between investigative detention and a custodial one, is that the latter, meaning custody, involves coercive conditions as to constitute the functional equivalent of an arrest. The one thing I also wanted to notice, and I know I'm not trying to get away from the interrogation, I'll be glad to answer any other questions on that. But of course, we know that there has to be both interrogation and custody. Putting aside the agency issue, Santiago case, whether the doctor acted as an agent of the police, there's clearly no custody here. And the cases that support that are 3 cases, well, one in New Mexico and 2 others. State v. La Couture, 2009, NMCA 71. And that's the case that was provided in the notice of supplemental authority back in March. And La Couture, some of the things they say in that case are almost 100% applicable here. What La Couture said was, La Couture, and this was, he had been involved in like a DUI or some kind of accident. He was in the hospital for injuries. And what the court said was, the fact that La Couture, this is paragraph 18 of La Couture. The fact that La Couture was restrained by injuries and medical accoutrements warrants little consideration. This is a Judge Kennedy Court of Appeals opinion. Locketeur was exposed only to circumstantial restraints, and as stated above, the record indicates no action by Officer Diaz to restrain him. And Locketeur, just to be clear, is not an outlier whatsoever. In the reply brief, I cited State v. Garrison, a July 2024 Connecticut Supreme Court case. And
So is it your argument today that the custody was circumstantial custody? Because it's not like, I mean, she's just delivered a baby, is bleeding out. It's not as though she's going to flee at that point. So are you asserting that there was no custody at all, or is it circumstantial custody from your perspective?
Well, custody, of course, can be formal arrest or, as the cases talk about, a restraint on liberty that basically, what's this, how they phrase it? Yes, when the person's freedom of movement has been restrained to a degree associated with a formal arrest.
So that was a follow-up question just Bacon I had, which is, so is the restraint of movement of the defendant based on the condition or that there were officers in the room? Does it matter?
Yes, I don't believe it does matter because Garrison and there's also this Johnson case that I cited in the notice of supplemental authority 2 weeks ago talk about the fact that if you're in a hospital, yes, officers may be present, but if the officers are not doing anything additional to limit your freedom of movement and they're being polite, they're not being antagonistic, that alone is not enough for custody. And in Garrison, it talks about an example in Garrison at page 289, it's 323 8th 289. The court says, because there is nothing in the record to suggest that any of the officers with whom the defendant interacted were threatening or aggressive, we conclude that the tone and tenor of the questioning weigh against the conclusion that the defendant was restrained. And I can't find it off the top of my head. The court talks in there about the fact that the real key is whether the police did anything to further restrain the movement. And probably the case that really best addresses that is the Johnson v. Commonwealth of Virginia. This is again 2 weeks ago, notice of supplemental authority, 916 Southeast 2nd 910. And what the court says in that case at page 921, so this is 916 Southeast 2nd at 921, the court says, the medical equipment connected to Johnson would have made it difficult for him to get out of bed, but his immobility was not caused by the police. Johnson was receiving essential medical care because he had shot himself in the chest.
I follow all of that, but here the police didn't like leave. They stood outside the door. They said, we're standing outside the door. They shut the door. Isn't that some evidence of restraint or custody where they didn't have to, handcuff her because she's medically unstable? But isn't the fact of their presence and standing outside the door to prevent somebody from coming and going, and they're monitoring exactly where she's going, they know she's going to be transported, all of that, isn't that some indicia of further restraint based on the language you just read to me?
I don't believe that would meet the test of State v. Munoz cited in the brief, which is the degree associated with a formal arrest. Because again, when you look at Locketeur, Johnson, and Garrison, they really are saying that yes, you may have an IV line, maybe you're injured, you may not practically be able to leave the hospital, but the police aren't doing anything to further restrain you. So I don't believe them waiting out in the hallway would be custody, but certainly any such finding would have to be limited at least to the point about 3 minutes into the lapel video when they say you are being detained, you're not under arrest, but you're detained, you're not free to leave. But unfortunately, the trial court's ruling suppressed even the statements you made earlier when the police literally were just standing there not saying a word and the doctor was talking to her. I know that gets into the agency issue.
Well, it also gets into the privilege issue, and your time is limited here. Setting aside Fourth Amendment for purposes of our conversation and the privilege, it appears that the state is taking a position that everything that the victim said is admissible because of the doctor's requirement under statute to report that as a crime. And I'm struggling with that. I can see the doctor, as she did, say we have a deceased individual and I need to report that. but the rest of, it seems at that point, you're just opening it up and all the privileges are just waived and whatever that defendant talked about is admissible. Can you address the privilege issue?
Yes, I'll do it very quickly and I'll be glad to do it more on rebuttal. Two things, 11504D4 does have the exception, and as I noted in the brief, this court clearly has, as the issuer of that rule has, and I mentioned this in the brief, has a common law ability to interpret that rule. I would say 11504D4 certainly covers this, but the other big issue is the waiver. The fact that she spoke to the doctor with the police present and her mom present.
Okay, so mom's there to take care of her?
Well, she was 19 years old though.
Okay. And the officers, to Justice Bacon's question, and you can address this, I'll give you some time. They were at least guarding, at least if we're not going into the Fourth Amendment, they were in there. So that's a struggle with that waiver.
And she's on a myriad of drugs.
And I understand so real quick, the only thing I would say, Your Honor, if you allow me 10 seconds, is that
It's okay, it's okay.
imagine if the situation had been, the doctor had gone in before the police got there. Let's say the police were on their way and the doctor goes in and says, well, I'm sorry to tell you, but we discovered a dead baby in the bathroom. And then she says, I'm sorry, it came out of me. I didn't know what to do. I think that would not have been privileged. And let's say the police arrive 3 minutes later, because that goes to the heart of the D4, 11504 D4 exception. So I think one way to look at it is, had she made that statement in response to the doctor's statement, we found a dead baby in the bathroom, even had the police not been there, I believe that would have not been privileged under the spirit of State v. Strouch and 11504 D4. And I'll sit down and wait.
No, don't.
Take your time.
Justice Moore has a question. Justice Moore, did you?
I was more clarifying that you talked about the mom being present during the conversation and the statements made by defendant. And yes, the defendant was 19, but I might be remembering wrong. It's entirely possible. I want to see if I am. Wasn't there something she signed authorizing her mom as like a caretaker or a party that she wanted?
Contact?
Maybe something where she wanted her to be present during the medical treatment. And does that do anything with the waiver issue? If my question makes sense.
I don't know if I can answer that off the top of my head without going back and looking at the record, but I believe that the general rule is that the presence of a third party is not strictly necessary, like a paralegal being there during an attorney and client conversation causes it to be waived. Thank you for the answer.
Thank you, Mr. Thomas. 10 minutes.
Thank you. Yeah, I just wanted to start off, Your Honor. I will try to talk slower.
It's a lot. It's a lot. I think as you have this conversation, if you can help us separate the Fourth Amendment part and the privilege, but go ahead.
Yeah, and I did make some notes, and please jump in with questions, but I did make some notes about just a few things I wanted to really hit quick. One is that I don't think there's any issue here about whether the doctor had a duty to report, because whether you call it under 32A43, and I did realize that 32A43 talks about a neglected or abused child, but as I pointed in the brief, just from this court's common law interpretation, and it would be odd to say, well, you have a duty to report an abused or neglected child, but not a dead baby. And I'm not going to read much. I don't want to get into the details much, but the defense's own Exhibit D at the suppression hearing, the defense's own Exhibit D, as in Delta, talks about how the Leela, the custodian lady, what caused them to call the police was that she had found a baby wrapped in a trash bag under another trash bag. Now, as sad as that is, clearly that's a suspicious death. No different than if a 30-year-old had been found in the cleaning supply room with gunshots to the head. And so I wanted to make a few other quick points. So in custody, I know there was a lot of talk about what the charge nurse said, and I maybe didn't articulate this really well earlier, but my point was that whatever was told by the charge nurse to the police would not have affected the defendant's objective, reasonable view. It's an objective view of what a reasonable person in that situation find themselves to be in custody. And none of what was said to the police in the hallway would have been known to her. It's worth just a few.
But it's not about what was known to her. It's about what was known to the police when they said, yes, sure, we will go into the room and have the conversation with you, because that's their yes to the statement. So it's not about what she knows. It's about what the police know and what their motivation was to go in the room and have a conversation with Ms. Trevizo.
And I understand that, but and certainly if the police had gone there, gone home with their guns drawn or something, saying you're not going anywhere, you know, and immediately have made it clear you're in custody.
But they don't have to say any of those things for it to be custody.
And I understand that, but certainly what the defendant is perceiving or hearing is really, what is the defendant perceiving and reasonably hearing and seeing? The one thing I wanted to point out is this reference to the police being armed. I mean, it's common knowledge to anybody the police are armed. They could be safe 1 minute and 10 minutes later be dealing with a very dangerous situation. I'm not saying in any way, shape, or form the defendant was
But what about where they were standing in the room? Opposing counsel talked about their location in the room, which is in front of the door. That doesn't seem to support your position that it was not in custody.
Although I would argue that the fact that for nearly about 2.5 minutes, they said absolutely nothing. They just stood there and observed certainly bears on defendant's perception. Just a quick 1 or 2 quotes from Garrison, because Garrison really, the Connecticut case gets to the heart of this. Garrison talks about not all restrictions on a suspect's freedom of action rise to the level of custody. And then they go on to talk about whether a reasonable person would believe that there was a restraint associated with a formal arrest. But another thing that Garrison mentions, I guess this is the part I looked for earlier and I couldn't quite find earlier. Garrison says there's nothing in the record to suggest that a reasonable person in the defendant's situation would have perceived the police officers to be exercising any control or authority over the medical staff. Indeed, the record demonstrates that the officers did not assert control over the medical staff and that the questioning did not delay, interrupt, or restrict the defendant's medical care. I don't want to belabor the point, but if you do get a chance to see in Johnson, the Virginia case from the notice 2 weeks ago, Johnson gives a list of the kind of factors that might be relevant in a hospital, and one of them is whether the police maintained a constant presence in the patient's hospital room. As I noted, from about 3 a.m. to when she leaves in the helicopter at 4:30, you can tell from their camera they're out in the hallway. But one other thing I wanted to
But
mention.
they've told her,
And I understand,
We're out in the
but she had already
hallway.
made the statements.
And they,
which is equivalent to being in the room, to be like, we're standing out right outside the door.
Yes, but again, at the point of the 3 minutes into the lapel video, when they tell her you are detained, you're not free to leave, you're not under arrest.
You're the one who
detained.
raised they were outside the room. You want to focus on the 3 minutes, but you also want to focus on, oh, they were good guys. They left the room after the 3 minutes. Can't conflate it.
And I understand, but my only point is that even if the court wants to consider the point where she's told she's detained to be custody, the motion should have been more specific on that, because I don't think there's anything in the first 3 minutes until she's told she's detained that would lead a reasonable person to believe they were in custody. And I would be remiss without at least mentioning this. If you look at the judge's findings at RP 159, I'm sorry, 158. The judge in her conclusion of law number 3, record proper 158, the judge says, Dr. Vasquez, by failing to advise Trevizo of her right of confidentiality, and she cites Rule 11-504, acted as an agent of law enforcement. I'm not reading the entire paragraph on RP 158, paragraph 3, but the judge seemed to be reasoning that because the doctor did not go in and affirmatively say, before you say anything, you have a physician-patient privilege, that the doctor's failure to advise the defendant of that made her an agent. There's several problems with that. That's not the test that Santiago provides. Santiago, of course, is the case. This court, 2009 NMSC 45 says, it's A, whether the government knew of and acquiesced in the conduct, but 2, whether the party performing the search intended to assist law enforcement efforts or to further his own ends. And Santiago makes it crystal clear in paragraph 24. It makes it clear that if it's a mixed motive, that's not enough. So in other words, even if the doctor was thinking, I do want to help the police, but I'm also concerned because I'm the doctor, I'm in charge of the ER, it's 2 o'clock in the morning, there's going to be Artesia General Hospital Board of Directors to answer to. I need to find out what's going on. I also need to find out how it impacts her care. Because one thing that's clear from the video is the doctor throughout all this made it clear, your care is paramount. Even Sergeant Anaya says, the number one priority is your care. We're going to step out if we need to, and the number one priority is your care. There's no evidence in the record that the doctor was motivated solely to help the police.
wait a minute. This girl goes into the emergency room. She's got these backaches. She's asked, are you pregnant? She says no. They then do a pregnancy test. It comes out positive. They don't tell her. They don't tell her that the test shows she's pregnant. After the baby is delivered in the bathroom, So she comes in and says, we found a dead baby in the bathroom. Worse to that effect. It gives weight to the assertion that they thought from the beginning, the doctor thought from the beginning, she lied when she said she wasn't pregnant. And now she's confronting her without the benefit of having given her any medical information that she in fact delivered a dead baby. So that seems to me pretty agency oriented in terms of assisting the police.
Well, again, Santiago says that it has to be solely to help the police. Santiago says that there's any kind of mixed motive, like you have a professional
An
interest.
inference can be made, it is solely to help the police.
I don't believe that inference can be made under Santiago, but I will say this, Justice, and I think this points to a good point. Even if you give the defendant the benefit of the doubt that she did not know she was pregnant, immediately upon giving birth, the natural thing you would think anybody would do is, help, help, I just had a baby, help, help, I need help. She did not tell anybody for 30 minutes. It was 30 minutes later that the cleaning lady found the baby, and obviously another 5-10 minutes till the police showed up. I think one can make a good argument that she did not even from the beginning avail herself of the physician-patient privilege. State v. Roper, 1996 NMCA 73, paragraph 6, said the privilege is designed to encourage patients to make complete disclosures of symptoms. I would argue that if you're hiding a material fact from the doctor that you just gave birth to a baby, you're not asking for help, arguably you're not even availing yourself for a privilege. Now, I understand after the fact, now that she's caught and she's in trouble, she wants to say, my privilege was violated. But State v. Strouts, 2015 NMSC 9, paragraph 44, states expressly, privileges often have limits, particularly where there are conflicting interests that may outweigh the interest of confidentiality. And it's interesting that Strouts notes in paragraphs 29 to 31 that New Mexico in 1973 became one of the earliest states in the country to impose a mandatory reporting duty on all persons. So New Mexico has a rich history of protecting children and babies. And the other one more thing I wanted to note is it's also interesting that some of this privacy and privilege is a little bit pick and choose what serves me. There was a lot of emphasis in the answer brief about privacy, and they didn't respect her privacy. And yet there's something in the answer brief where they say, well, the hospital let her go to the bathroom unattended. Well, she's 19 years old. It's ludicrous, almost incredible to me that they expected the doctor to go into the bathroom or a nurse to go into the bathroom and stand over her to make sure she didn't do anything. So there's got to be some treatment of, you're 19 years old, you're a responsible adult. I think that's been a little lacking here in terms of the defendant certainly has rights, she's on trial, but there has to be something said for the baby's rights too.
Thomas, anything else? Any other questions? All right, thank you.
Thank you, Your Honor. Thank you for the good questions.
In the matter of S1SC 40478, the court appreciates the briefing and oral argument today. This matter will be taken under advisement and is deemed submitted. Court is in recess. Thank you.